Assalamu alaikum and greetings to our lecturer, Dr. Nurli. We represent Group 4 and these are the presenters.
Hello there, hi. My name is Dunil Amzar binti Azmir, metric number 265076.
My name is Miza Fazana binti Faizul, matrix number 264146.
Assalamualaikum warahmatullahi wabarakatuh. My name is Mastura binti Mazlan, matrix number 26497.
My name is Nur Sofia Basara binti Nordin. My metric number is 264230.
Greetings, my name is Nura Amira binti Muhammad Zaidi and my metric number is 264245.
The case that we want to present today is Expo Holdings Syndrome Berhad and others and Toyo Inc. Group Berhad 2014 10 MLJ 674. Without further ado, let's get started. The flow of our presentation will cover: first, facts and health of the case; second, arguments of plaintiff; third, argument of defendant; and lastly, analysis of the principles of law. In Malaysia, matters with respect to the powers and duties of the Board of Directors, together with the rights of the members, are provided under the main governing act, that is to say, Companies Act 2016. In this context, reference was made to the 1965 Act as to accord with the time frame of the case. Generally, it is not imposed for every company to have their own memorandum and articles of association, M&A, or more commonly known as the Constitution of the company. Nevertheless, it is worthy to note that for the companies that reserve such constitution, it shall not exceed the supremacy of the Companies Act in any manner. Hence, there is an urge to examine such laws and to demarcate the line between Companies Act and the company's constitution. This presentation intends to review a case law pertaining to such matters on issues of right to alter the M&A and whether it fulfills all necessary conditions, such as in line with the Bursa requirement, attain approval of the members, and advices from the experts, and subsequently done in the best interests of the company in a valid and properly manner.
Facts of the case. In this case, the company's minority shareholders challenged the validity of two resolutions passed by the board in general meeting. This resolution was passed as a plan to raise capital for the company to fund the company's operations by issuing new shares and also to reduce company's debt. The first resolutions that are being challenged by the minority shareholders was the issuance of bonus issue on the basis of one new share for every two right share subscribed by the existing shareholders. The second one is the amendment to the Defendant's Memorandum and Articles of Association as a consequence of the proposed right issue, proposed bonus issue, and proposed increase in the authorized share capital. They claims that the issuance of bonus was void as it was against the Article 30 of Companies Article of Association. The director's decision to make a bonus issue of shares was not in the best interest of the company, as the bonus issue was only made available to those existing shareholders who subscribed to the right issue. The court held that the original article worded in such way that the directors are given discretion to capitalize profits to the members who will be entitled to it by way of dividends, and in the same proposition. The amendment of Article 30 expanded authority to cover the bonus issue. The court considered that since the amendment was done in the best interest of the company, the bonus issue and the subsequent amendment to the memorandum were valid.
Assalamualaikum and a very good day to everyone. My name is Mastura and I will be explain plaintiff arguments in this case. So, what are the plaintiff's argument? Plaintiff, who is a minority shareholders in this case, challenge Resolution 2 and Resolution 4. They claim that these resolutions were null and void, and it were ultra-vires to the defendant's memorandum and article. Plaintiff contended that the original Article 130 of defendant's M&A did not allow the corporate to exercise the resolution 2. Then, there is a special resolution to propose to amend the company's memorandum and article of association. Plaintiff argued that this amended article cannot cure the illegality of the bonus issue, as it was not permitted in the beginning, as stated in Article 130. The plaintiff said that company may always alter its memorandum and article of association by special resolution. But then the company is still subjected to Companies Act, and such amendment must be made in bona fide. There must be a bona fide done for the best interest of the company as a whole. However, this resolution will create two different classes of ordinary shareholders by giving bonus shares to only particular group of ordinary shareholders. The plaintiff, who is a minority shareholder, will not get the benefit. Therefore, this cannot be said to be in bona fide interest of the defendant. Defendant must make sure that it is for the best interest of the company as a whole. Plaintiff state that Section 65 of Companies Act 1965, which require all ordinary shareholders to be treated equally, have been violated by the defendant. Thus, from these arguments, plaintiff claimed that Resolution 2 and Resolution 4 were null and void.
My name is Sophia. Now I'm going to continue with the defendant's arguments in this case. The defendant, Toyo Ing Group Berhad, is a public listed company in Bursa Malaysia Securities Berhad, also known as Bursa. The defendant chose to respond to 4 resolutions passed during the extraordinary general meeting with the shareholders instead of issuance of bonus issue and amendment of company's articles and memorandum only because the defendant claimed all the resolutions were interdependent to each other. The defendant's argument and response on regarding the issuance of bonus share is that all shareholders were given same entitlement of the right share allotted to the shareholders under ordinary resolution of proposed right issues with warrants. Then, the allegation that the defendant's issuing bonus share will create 2 different classes of shareholders as claimed by the plaintiff was counter-argued. Aside from that, since the nature of defendant's company is a public listed company, they argued that the plaintiff can sell their shares to the public to overcome the financial difficulties in finding funds to buy the share. Next, the second issue that the plaintiff raised is the issue of the amendment of company's articles and memorandum, where the defendant argued that the amendments of Article 130 of the company's memorandum and articles was necessary for all 4 resolutions to come into force. The defendant also claimed that their board of directors had acted in good faith for the best interest of the company to reduce the company's liability of borrowings and increase the capital income by issuing these resolutions. Thus, the amendment has to take place. Although the amendment of the article will affect the position of minority shareholders, which were the plaintiff, the interests of majority shareholders and defendant must be prioritized and prevails. These are the arguments that the defendants brought into the court.
Assalamualaikum and a very good day. I bid to Dr. Nuli. My name is Nurul Amira binti Muhammad Zaidi and I would like to present about the analysis of the case Expo Holding Sdn Berhad and Toyo Ing Group Berhad. Directors of the company have to exercise their duties accordingly in order to direct and manage the companies to become a good company. In referring to the Section 213, subsection 1 of the Act, it is provided that a director must carry out his or her duties and responsibilities in regard to the company with the reference to the Act, and such duties must be done with the aim of proper purpose and good faith in the best interest of the company. In relating to the case review, the element or duty related is duty must be done for a proper purpose. Proper purpose stated in the provision can be viewed as any duty or decision made by a director which must be related to the objectives or purposes of the establishment of the company, which usually can be seen in the constitution of the company. Anything that was done in contrary to the objectives of the company can be determined as not for a proper purpose, thus breach of a director's duty. Two-step analysis is adopted by the court in order to decide whether the power exercised by the director was done for a proper purpose or not. The first step of the test is the court will look into the particular power that in question and its legal purposes that the powers were permitted to be used. The second step is the court will proceed to follow the fact of the case together with the intention of the director before deciding the actual purpose regarding the power exercised. In the matter of where the company is in need of capital, generally the directors are given power to make decisions on how to increase the capital, but such directors need to prove that the decision made or option taken is for proper purpose. In the case of Expo Holding Sdn Berhad and Toyo Ing Group Berhad, the minority shareholders alleged that the directors had made decisions regarding the issuance of shares and it were done not in the best interest of the company because the issue of shares only made available for certain shareholders that can create two classes of shareholders with different rights. However, the court held that the original article gave the discretion power to the directors on how to capitalize the profits and later the amendment was done in the best interest of the company, thus the bonus value it was valid. This is because there was enough evidence provided by the company to prove that the decision made was for proper purpose, which it was done to encourage the participation in the rights issue among the existing shareholders. There was also a supportive advice given from appropriate professionals regarding the exercise of the discretionary powers by the directors to opt in order to raise the capital. Thus, the directors had done their duties for proper purpose and were able to prove to the court that they were not in breach of their duties.
As discussed above, it is clear that the powers exercised by the Board of Directors were in conformity and consistent with the Companies Act 1965. It is of the essence to mention that there was an explicit approval by the Bursa prior to the circulation to the shareholders. Regardless, every voice must be heard, but it cannot be denied that all resolutions were adopted by the shareholders in majority during the extraordinary general meeting. Thus, all conditions have been fulfilled. Well, that brings us to the end of the presentation. We would like to thank you for your time and attention. See you later.